I'm a program assistant with the University of Maryland Extension here in Garrett County. I'm thrilled at this large crowd. When I made plans, I told the girls in the office, I think 30 copies of everything will be enough. Yeah, we've gone through 60, now probably 70. If you did not get handouts, go to our website. By tomorrow afternoon, probably late morning, we will have the handouts available as files on our website. So I apologize that I underestimated the size of the crowd this evening. Our topic for this evening is the Dormant Minerals Interests Act, and this was introduced to our state legislature by Delegate Wendell Beitzel and Senator George Edwards. I was horribly remiss when I left his name out of our PR pieces that we did for this. Tonight, our attorney, a local attorney, Cristine Kepple, who is a graduate of the University of Maryland and West Virginia Law School, is going to be our speaker and explain some of the finer points of this to us. I'll say for her what was said to me at another seminar that I went to. She is an attorney, but not our attorney, so that she'll be able to answer questions, but maybe in generalities rather than specifics. Appreciate everyone coming tonight. And with no further ado, I'd like to introduce Cristine Kepple.
Thank you. I have to confess that I have a pretty bad cold. I feel a little worse than I sound, and I'm under the influence of several different kinds of medications, so I can stand here tonight. But I do have a real problem with breathing and talking at the same time, so I may have to take turns doing those things as we go through it. I want to keep this pretty informal. It is a little bit of a large crowd to keep things on an informal basis, so the one concession I am going to ask is that you keep your questions until the end. I'm going to try to answer as many of your questions as I can and as time allows. I am going to keep us focused on the topic, however. This topic of gas in the Garrett County area and minerals in general have a lot of different aspects to them, and people have a lot of different opinions about that. And the topic for tonight is going to be on the Dormant Minerals Interests Act, and we're going to hold it to that topic. That way I can still stay awake long enough to answer your questions if we keep it on course here this evening. When I agreed to do this seminar, I was pleased to do so because the University of Maryland Extension Service played a great role in my life. I was raised in Garrett County and came up through the 4-H programs, the FFA programs, and noticed many of you in the crowd that I recognize from the community. I went to the University of Maryland and majored in agricultural and resource economics as my undergraduate bachelor's of science. And so farming is not only close to my heart, it's something that I still do on a second job basis in addition to my paying job. With my husband Rick, we have horses and we do some crops and so forth in the Pleasant Valley area on a farm that we purchased there. We do own the mineral rights to our farm. So not only am I an attorney who's interested in this from the standpoint of legal rights, but I'm personally interested in this as well. When this issue became one in the forefront locally, I was involved as a landowner as well as an attorney, so I've got both of those perspectives, and I know many of you here tonight have also been through some of the leasing activity or have been following some of the leasing activity that's occurred. I want to give you a little bit of background, though, on the legal basis for mineral interest ownership and how that mineral interest ownership can be separated from the surface of land ownership. Traditionally, real estate ownership was from the center of the earth to the heavens, and that was an entire fee simple ownership of property. As modern law evolved, we came up with many different ways to split up that ownership in the way that we could hold title to property or fractional ownership in property. Mineral rights severance is consistent with the idea of horizontal severance. In other words, you can divide mineral ownership interest into strata or into formation and actually have certain coal strata owned by one person and coal strata below that owned by another person, or have certain rights or leases related to those different horizontally severed minerals. In addition, you can sever the types of minerals. One person could own the gas rights below a piece of property, while another person owned the coal rights. And there are all kinds of questions relating to what happens when those rights conflict with one another, in addition to the ownership of the surface and how that interacts. You know, modern land ownership has created a lot of different kinds of estates as well, even with surface. You're familiar with the idea of owning a condominium, where you don't actually own the entire real estate that your building might sit on or that your apartment might sit on, but instead you own a condominium, which is a right to a particular unit. In Garrett County, we've got this animal we call the land-dominium, which is where you own sort of a parcel that you can sit a building on, but you don't own the common areas around that small parcel. There are things like timeshares, where you own a week. That's a week's right to live in a condo or in some other kind of, usually a resort facility. So you can see how the modern law has created different ways to break up the ownership of real property. Excuse me. We also fractionalize ownership of property in different ways, like term of years and also life estates. And so when you look at the idea that someone could own a defined ownership of land or a defined incident of ownership of land, but own it for only a period of time, you start to combine these concepts, where you might own a life estate in the coal rights, and then upon your death, those coal rights go to another party or revert back to the surface owner. It gets very complicated about how people can divide these rights. In addition, with minerals, you can have executory rights and non-executory rights. Executory rights are those that come with the ability to negotiate the right, and a non-executory right does not give you the right to negotiate. So if I were a gas company wanting to enter into a lease with a landowner that owned the mineral rights, and that landowner owned, say, 1/2 of the gas rights as well as the executory rights, that would be the person that I would negotiate with, because the person who had the non-executory rights did not have the right to make that deal, even though they might enjoy the economic benefit of the 1/2 interest. And then, of course, there are royalty rights, which can be severed separately from the mineral interest itself. So if I've thoroughly confused you, my whole point is to say that there are very complicated ways that you can own these interests. And when you start to investigate what you yourself may own, or the ownership of some third party who might own the mineral interest underneath your surface, all of these questions need to be analyzed and answered. And sometimes there's not an easy answer to that process. Many of these ownerships are created and are very old, and the language that was used to create them are not consistent. As we try to modernize things, we try to be very consistent about the way we describe those rights. But in 1910 or 1880, they weren't nearly as consistent, and those inconsistencies create problems as well. It's interesting to note that the reservation of mineral rights can create an implied easement to remove those rights as well. And that can be another bundle of rights. And sometimes those bundles of rights are inconsistent with that of the surface owner. In Maryland, there's very little case law on a lot of these issues because, quite frankly, there hasn't been a lot of activity in this area in the law, and a lot of it has centered around coal and coal extraction. And because Garrett and Allegheny counties are the only two counties in the state that have significant coal reserves, you can see that that just hasn't led to a great breadth of case law that controls these kinds of things. So Maryland has the unique problem that a lot of these issues that might have been resolved in other states by case law have not necessarily been resolved in Maryland. So there are a lot of issues that are up in the air, including ways to interpret some of these ownership rights. For instance, in Maryland, we do have a case that has a holding with respect to surface rights and what is meant by surface rights when it's referenced in a deed with respect to a mineral right. It says it's the use of the surface where necessary to access those minerals. That doesn't really define it any better for many of us than just say, well, I own it and I can go and get it. Specifically, if there's an implied easement is one that, just what it sounds like, it's implied by nature of the ownership. The owner of the mineral rights must take reasonable efforts to limit the destruction of the surface, and those rights are determined by the circumstance. In addition, there are other holdings that say that those rights are dependent on the method that would have been removed at the time the mineral right was granted, or the time the mineral right was reserved. Now, again, that's a huge ambiguity. So we're going to see going forward, I believe, a whole new body of case law created in the state of Maryland to interpret those things under Maryland law. Now, we can borrow case law from other states on sort of an advisory basis. So we may look to what Pennsylvania does, we may look to what West Virginia does, we may look to even what other states further away have done. But that doesn't necessarily control how Maryland will interpret some of these issues until an actual Maryland court interprets them through the appeals process. Excuse me. In 2008, when a lot of the leasing activity really increased, there was even the unresolved question of what does minerals really mean under Maryland law? Was there a definition of what minerals meant? And there was some debate about whether minerals were sort of the hard substances and the gas were something different from minerals. And so if you owned mineral rights, did you then own the gas rights, or did you not own the gas rights? Senator Edwards asked the chief counsel of the Attorney General's office, his name was Robert McDonald, to write an opinion, and it was really kind of an advisory letter with respect to these issues. And in September of 2008, he did so. And in that, I quote, he said, "Ordinarily, minerals or mineral rights in a deed of conveyance will be interpreted to include all inorganic substances that can be taken from the land, including oil and natural gas." So in that opinion, oil and natural gas was a part of minerals. However, if evidence shows the grantor and the grantee intended a different or more restrictive meaning, that meaning will prevail. The term mineral rights, what is included, what is excluded, ultimately depends on the intention of the parties to the deed at the time of the conveyance at issue. Now, if you think attorneys can't give a straight answer, here's an excellent example. Who's to know what the intention of the parties were in 1903 when granddad or great-granddad reserved the coal rights under the farm? So you can see why it's very difficult to express to a layperson, here's the yes or no answer, or here's the bright line test. So often it's a case of interpretation, sometimes it's a case of interpretation of a court. And again, we don't have a lot of existing case law to lead us in any bright line direction. Excuse me. So what happens when you start talking about the history of natural gas and how far back you need to look to get the answers to some of these questions? Well, I tried to look on the internet because those are the places we all go to get answers these days. And West Virginia claims to have had the first gas well. Now, I don't know if this is true or not. This was from a tourism West Virginia site, so I'm not going to put a lot of credence in it, and I'll let you take it for what it's worth. But they say that in Charleston, West Virginia, in 1815, a gentleman by the name of Captain James Wilson accidentally struck natural gas while drilling for salt near the foot of the present-day Brook Street in Charleston, West Virginia. You can imagine his surprise because he discovered it by having an open flame too near his salt mine. So I'm sure when something exploded, he decided he had something on his hands more so than salt. But it took many years then to have actually an industrial application for gas. And that's accredited to a William Tompkins, again in West Virginia, but again from the same resource that I just quoted, so we'll take it for what it's worth. In 1841, William Tompkins was the first man to utilize natural gas in the manufacturing process. He carried the fuel through wooden pipes to his salt furnace at Burning Springs. This was long before the days of OSHA. West Virginia and the Kanawha County then claims to be the predecessor of all of these gas wells and gas exploration. The first gas well was about 60 feet deep, and that must have been some extremely shallow gas. It probably would have been a case where you could have lit the gas off just digging a hole for a plant at that point. From there, of course, there's been a great deal of technology development leading us to the current technology that we're seeing interested in our area, which is that of the Marcellus Shale. In 2003, in Washington County, Pennsylvania, Range Resources drilled the first Marcellus gas shale well to use the horizontal drilling method in our area. Certainly activity out west preceded that, but that was the first we saw it in our region. The first well that yielded commercial qualities of natural gas was also in Washington County, Pennsylvania, and it was drilled in 2005. In our area, we started to see some leasing activity and some interest about 8 years ago, and they kind of came quietly into the area, and interest built from there. Many of you know that in late 2007 and the first 3 quarters of 2008, there was a great deal of leasing activity in the area, and some people leased up during that effort. But that's when you saw multiple landmen coming into the county, negotiating for terms and trying to enter into leases, many of which were not finalized because the credit markets and other economic indicators brought that whole market to a crashing halt about October of that year. Right now there are several permits underway in the Finsel area, and there's also some initial seismic testing that is going to be done in the Friendsville area. So that's really where we find ourselves right now. So is there additional interest in leasing in this area? Yes. Is that interest somewhat slowed down by the fact that we don't have wells here to verify the resource, or we're working through the permitting process on the state level and we don't know how long or how difficult that permitting process may be? Yes, all those things have slowed down the level of production here in Garrett County. We can look to Pennsylvania and look to West Virginia to see some of the additional activity that's there, that's going on in industries that have been well established for more years than we have the industry here. During the process of this leasing fervor that occurred in 2007 and 2008, landowners became aware of many problems with respect to their ownership of mineral rights. First of all, people looked to their deed, and the deed that they held currently did not always tell them whether or not they owned their mineral rights. In addition, they looked at the land records and maybe found that they owned a portion of the mineral rights but could not determine who owned the other portion. So they may have wording in their deed that says 1/2 of the mineral interest goes with the surface, but where in the world is the other half? In many cases, mineral interests were deliberately left out of estates many generations ago, either because they were deemed to not have value, or it wasn't worth the trouble to either fill out the paperwork or secure the appraisal or valuation for those mineral interests required to administer it through the probate courts. So it's more convenient simply to sort of forget that granddad owned these mineral interests and just leave it off the inventory. In some cases, fractional interests through multiple generations became so small that they were perceived not to have sufficient value to deal with the inconvenience of the paperwork and so forth to transfer that forward as well. Some mineral owners found that certain aspects of their minerals had been severed. For instance, they didn't have the coal rights, but they did have the gas rights, and vice versa. In addition, we have difficulty identifying some parent tracts of land because their legal descriptions were vague in the very old deeds in which these rights were established. And so the other concern with respect to clarifying ownership of minerals is not only that of legal chain of title, but also of the actual description or legal description or survey of the tracts that contain those mineral interests. So these and many other problems came to light during this effort. And what many people found was that once a gas company started searching the ownership of their minerals, when they ran across any problem, be it a fractional ownership that was missing, or if their tract was made up of several old parent tracts and one of them already had a mineral reservation, the gas company would just simply say, I'm sorry, we're not interested at this point, you'll have to resolve those issues. Call us when you do. And there wasn't time in this sort of fervor that was going on in late 2008 to resolve these issues. Even with all the time in the world, it's difficult to resolve these issues without an act like the Dormant Minerals Interests Act. Unlike surface rights, mineral rights can't be adversely possessed. And adverse possession is a concept where if you exclusively and notoriously occupy property for a period of greater than 20 years, you can claim certain rights, and you can go to court to finalize those rights if no one else makes a contrary claim. Minerals, by their nature, can't be possessed unless they're actually removed. So even though I set up camp on your field, I might be possessing the surface, but I'm not necessarily possessing the minerals. It is possible to have certain possession of the minerals if you do in fact go in and take them and you exercise that control over a period of years, but that's a very uncommon occurrence. Sometimes it's done with coal. As you can see, someone could strip mine, remove the coal, and say, here, now I'm adversely possessing it because I've actually got it in my trucks. It's very difficult to do that with gas. The challenge is to try to resolve questions of ownership when you have a situation where you can't revert to either an adverse possession argument or some other similar argument of abandonment, is that you literally have to go back in your chain of title and find out who the owners, the last known owners of your mineral interests were, and try to bring that forward in time. I've spent quite a bit of time with families trying to go through their family tree to figure out how many heirs great-great-aunt Anne had, because in her will she left all of her mineral interests equally to her 375 nieces and nephews. And to try to track that family tree becomes very difficult. It's also very difficult to try to track all those folks down to give them proper notice, to have the kind of action to quiet title or other action to resolve issues of ownership of the minerals. The Dormant Mineral Interests Act is designed to at least streamline in part many of those questions. Now, those of you that were able to get a copy of the handout, excuse me, have the benefit of some of the details here. I've been in this auditorium for a number of presentations, and anytime someone's tried to use a PowerPoint or tried to use the projector, it doesn't work very well in this setting. And I need glasses for distance, so I can never see what's on the screen anyways. So I decided we were going to do handouts and pieces of paper. So I hope that that's worked out, and I hope that there aren't a lot of you that weren't able to get a copy. I want to make a short remark before I go into the act itself about agricultural preservation. When this activity went on with respect to the leasing, there became a question about what could a person do if their farm was in ag land preservation with respect to the mineral interest. And the answer is, with maybe only one notable exception that I know of, the surface cannot be disturbed in the effort of trying to harvest the minerals or to produce the minerals. The Ag Preservation Board has taken a pretty hard stance on that, and they're not welcoming any changes, nor are they looking to implement any changes by policy in the Ag Preservation Program. Now, the legislature could potentially override that and actually legislate a change to that program to allow the production of gas or the mining of coal or what have you. But at this time, that has not been the case. If you are looking at putting your land in agricultural preservation, that is also something that you need to be aware of now, because they currently are not accepting land that either does not have its mineral rights, or that those mineral rights are not subordinated to the right of the easement for ag preservation. So what it's really done with landowners is force them to kind of make a choice if they're looking at putting their land in preservation today, or whether they're looking to lease the gas rights or other rights of their property now. You really do have to make a choice. Some folks that came into the program under earlier regulations have the ability to lease their gas, just not lease any surface rights with that. So with the horizontal drilling, it's possible that folks under ag preservation could have the gas produced from their farm through a horizontal well, but not by having the wellhead placed excuse me, on their farm itself. So that's an important consideration for landowners that are trying to determine which of these options they're going to pursue. The Dormant Minerals Interests Act, when it was passed, gave us the definition of minerals for purposes of the Act. And when we talk about minerals under the Act, we're talking about gas, oil and oil shale, coal, gaseous, liquid, and solid hydrocarbons, cement materials, sand and gravel, road materials, building stone, chemical substances, gemstones, metallic, fissionable, and non-fissionable ores, and colloidal and other clay, steam, and geothermal resources. Now, I don't know what all that stuff is, but it's all minerals under Maryland law for purposes of the Dormant Minerals Interests Act. The Act benefits two groups of people, as Michael has said. The first group of people that it benefits are those that own the surface but do not own the minerals. The second group of people that it benefits are those who own the minerals but do not own the surface. If you are a mineral interest owner but you do not own the surface, you are going to want to preserve your right in that resource by filing a notice under the Act. If you fail to file a notice before October 1st of 2011, it doesn't mean you've lost your rights per se, but you have exposed yourself to the possibility that you could lose those rights if the surface owner files an action under the Act to claim them, and then you do not challenge that action. And if you're a person who reads every legal notice in the newspaper, you probably won't be taken unawares. But if you miss a week or you miss a couple of weeks, this could happen to you if you don't pay attention. So the best advice is to file a notice if you know that you own minerals under surface that you don't own. The statute sets forth what needs to be included in a notice, and this notice gets filed in the land records. It identifies the owner, and a person who's legally authorized to act for an owner can file this notice. So if your great-aunt owns her mineral interest and she's not competent, she's in a nursing home, if you're her power of attorney, or her attorney in fact properly referenced under a power of attorney, you can file this notice on her behalf. Or if you're the guardian for someone who is a disabled person or a minor, you can file this notice on their behalf. If you are a co-owner, in other words, you're one of those millions of cousins that owns this mineral interest, you can file on your own behalf, or you could file on behalf of all of the owners. The information in the notice would include the name of the owners, the co-owners, or any other person who's legally authorized to act for the owner. It will also identify the mineral interest. Now this is where it gets tricky, because I've talked to you about the challenges of defining mineral interest from these very old documents. You have to be able to reference the location in the records where an instrument creates your ownership. So if the only instrument creating the ownership in the minerals is the 1903 deed to great-great-grandfather, you've got to be able to reference at least that document. The idea here being that you can't simply decide that you own minerals if you don't have some legal document or some grant of right to base that on. Being able to prove and identify that right is where you've got a challenge in the research through not only the land records, but sometimes the estate records and other death records. The other way you can identify your mineral interest is by a judgment or decree that confirms that mineral interest. So if there's been some dispute and a court has interpreted the ownership of that mineral interest and has ordered the parties' rights in some form of court order or court action, then you can make reference to that order as well. The legal description of the mineral interest is adequate if it's accompanied by a reference to the name of the record owner under whom the owner of the mineral interest claims. So this is that mineral owner who's sort of removed from the record owner. You might be the great-great-grandson, and that interest has not been handed down or transferred forward properly. You can make a general reference to any and all mineral interest of the owner in any real property situated in any county if there's a previously recorded instrument that created, reserved, or otherwise evidenced the mineral interest, or there's a judgment or decree that confirms the mineral interest. So you can't file a notice that says, I'm John Smith, and this notice is good for whatever mineral interests I own in Garrett County, wherever they may be, however they're described. That's not good enough. But if there is this body of documentation in either the land records recently or in a judicial decree, then you can make that more general reference. But you need to be very careful about that, because I think many of these notices are going to fail in validity based upon an inadequate legal description or an inadequate claim of title or ownership right. The reason the October 1st, 2011 deadline is important is because that is the date after which surface owners can file actions to exert ownership over those rights. So if you're a mineral interest owner, you need to file that notice before October 1st, 2011. If you want to file a notice thereafter, you can only do so under certain circumstances. Excuse me. I don't know why I had to pick now to get a cold. If you let the October 1st deadline go by, you may then be giving up certain rights. A late notice of intent to preserve the mineral interest, which has been unused for a period of 40 years or more preceding the commencement of an action filed by the surface owner right, cannot be filed. So you've got a foreclosure of certain rights as a mineral interest owner after that October 1st, 2011 deadline. Now, the second group of individuals that this act benefits is those that own the surface and do not own the minerals. This is probably the larger group of folks that this act impacts. I've talked about the many ways that mineral interests can kind of become lost in the shuffle. People may not know they own the interests, but if they know they own the interests and they haven't done anything with them for a long time, that creates a situation where there's the argument for them being dormant as well. So if I know I inherited it many, many years ago, and it's trapped in an estate, there hasn't been any subsequent leasing, there hasn't been any subsequent transfer, then they could in fact be considered dormant unless I file my notice of intent. Surface owners that are interested in establishing ownership of the underlying mineral interest have to be able to show that it's unused for a period of 20 or more years preceding the commencement date of the action. So these are deadlines that are important to look at with respect to your ownership. You also have to show that there was no notice of intent filed within the period of 20 years or more prior to the filing of the action. So we're not going to have to search back very far for these notice of intents initially. Initially, the period of time in which those notices are going to be filed are going to be from the date of the adoption of the legislation until October 1st, 2010. As this moves forward, there'll be a longer time in which those notices will have to actually be searched. The person who is qualified to file such an action must be the surface owner. It can be the heirs, successors, or assignees of the surface. Excuse me. But it has to be someone who actually has ownership in that surface by claim of right. The action has to be filed in the county in which the real property is located. So you can't file one action which covers all of your mineral interests in both Garrett and Allegheny County, for instance. You would have to file for your Garrett County property in Garrett County. You have to file for your Allegheny County property in Allegheny County. You can file this if you know who the owner of the mineral interest underlying your property is, but it's very likely that that person will come and defend this action and defend their ownership of the mineral interest. But if they don't, then this can benefit you as a surface owner as well. Because the big impetus of actually adopting this act was because we were unable to find owners or unable to find the heirs of owners, that is sort of the focus of identifying either unknown or missing mineral interest owners. If you're a surface owner and you're going to file this action, you must make a diligent inquiry in the vicinity of the owner's last known place of residence. You must make a diligent inquiry among the land records to try to locate these folks. So if you're a surface owner, you can't simply say, I really don't know who they are, or I know who they are, I really don't know how to find them, and that's good enough. Diligent inquiry is going to be something that is subject to a bit of interpretation, but you can't sort of deliberately fail to find the obvious. Public records are one good way to try to locate these folks. Genealogy records are obviously another good way to look for these folks. Land records where they own maybe other properties or their heirs on other properties are another obvious place. So anywhere that you've got good public records where you can locate folks, those are places that you're going to want to look to try to identify contact information for these people. The Act also defines what constitutes a use within the 20-year period of time. And this again is an area where in Garrett County we've had activity with respect to minerals. We've had gas leasing in the past, we've had coal mining in the past, but some of that has occurred much more than 20 years ago. And so a use would be an active mineral operation on or below the surface of the real property. It would be payment of taxes on a separate assessment of the mineral interest, which currently we don't have in the modern time. Recordation of an instrument that creates, reserves, or otherwise evidences a claim to or the continued existence of the mineral interest. So in other words, there's been a deed to transfer the mineral interest to you within 20 years. There's been a lease that's been entered into with respect to that mineral interest, or there's been a reservation. In the last 8 to 10 years, people have become more interested in actually retaining or reserving the mineral interest when they sell the surface of a piece of property. So if there is a more modern reservation, that also is an incident of use. Finally, a use can be a recordation of a judgment or decree that makes a specific reference to the mineral interest. And again, that relates back to a court action where there might have been some dispute over that mineral interest, or something where that mineral interest was actually the subject of a judicial action. If the court finds upon petition of the surface owner that all of these hurdles have been met and we can't locate certain folks, then we set up a trust, and the court can set up a trust on petition of the surface owner, which will be in existence for a 5-year period of time. And during that period of time, a trustee is appointed to be able to administer that mineral interest, and that gives an opportunity for any unknown individuals to come forward, for any unknown heirs or other individuals to be located, and for those interests to be properly apportioned. But during that 5-year period of time, the trustee is able to lease those interests to the landowner, who may then subsequently lease them to a gas company or to a coal company, to be able to move forward, to be able to enter into leases, to be able to produce those mineral interests. Excuse me. If at the end of the 5-year period, those interests have not otherwise been resolved, then the trust upon petition of the surface owner can be terminated, and that interest can be conveyed then to the surface owner. So this is not something that the surface owner is going to be able to implement and achieve ownership of that mineral interest in a short period of time. It's going to be a long and arduous process to be able to assert ownership of those mineral interests. The alternative of going back and trying to clear up title where we've got these other challenges of locating unknown folks and giving them actual notice make the Dormant Minerals Interest Act in the long run the more definite way to be able to claim title to those mineral interests, however, I believe. The question of what is the appropriate approach given your particular situation with your land ownership and the way that the minerals underneath your surface may be owned is going to be determined on a case-by-case basis. Clearly, if it's an easy situation where the unknown heirs or the non-located heirs can be resolved, then that's probably the faster way to take care of it. But in some cases, the Dormant Mineral Interest Act is going to be the only alternative to resolve questions of title. So what is the first step if you are a surface owner and you want to determine how to go about resolving these issues of mineral interest for whom you have no idea of the ownership? The first step would be to have a mineral search done of your surface property to try to determine when or if those interests were severed, and then try to track that chain of title forward to be able to determine if the current owners of that mineral interest can be ascertained. Mineral interests are different from traditional title searches in that the standard in the industry of doing a title search for either the purchase of property or for the financing of property is a period of 60 years. When you talk about a mineral search, you have to go back much, much further than that. And in fact, the standard pretty much currently is to go back to 1872, which was when Garrett County was separated from Allegheny County. And those are the land records that are available here locally. That date also pretty much matches with the technological advancements in the discovery of gas and when gas was being commercially produced. So when we're talking about gas interests, that time pretty well encompasses all potential severance of gas interests. In many cases, those interests were severed in 1910, 1903. These are very, very old severances. Those incidences of ownership of those minerals could carry forward in their own track of ownership. So in other words, when you track the chain of title of your surface, it will go through all your predecessors in title and come out with a current deed in your name. If those minerals have been severed in, say, 1903, there will be a similar forward chain of title for that mineral interest ownership that may go through either deeds or estates or both on its way to being in the hands of the current owner. Again, in many cases, that chain of title ends or sort of drops out for many of the reasons that I earlier discussed. Once you've gained as much information as you can, either by researching your own documentation or through that mineral search, then it's an appropriate decision point to say, how do we pursue the ownership of these mineral interests? If we can ascertain who owns them, do we make an offer of purchase if that title is clear? Do we, if those individuals cannot be ascertained, do we file an action under the Dormant Minerals Interests Act? Or if it turns out that we as the paternal branch of the family inherited the surface and the maternal branch of the family inherited the minerals, is there some family arrangement that can be resolved to bring those two interests together? And we've seen a couple of cases of that as well. One branch of the family did not want to farm way back when, so they found more value in receiving the mineral interest versus the surface. If you are the mineral interest owner and you want to determine what course of action you should take to protect your ownership, or even what your ownership consists of with respect to the minerals, again, a mineral search is the appropriate first step to trying to determine what the nature and extent of your ownership is with respect to those minerals and what you have to do to be able to protect your ownership in it. A mineral title search will tell you whether there has been any activity constituting a use under the Dormant Mineral Interest Act under the last 20 years. And so maybe you don't have to file a notice of intent. But for the most part, I think it's going to be good practice to file that notice of intent if you can ascertain your ownership and the location of those mineral interests. It's difficult for me to stand up here and say you absolutely positively have to have an attorney file that notice for you. But I will say that given the challenges of defining the ownership interests and the challenges of creating a legal description for those mineral interests, given the typical state of those very old deeds, yeah, you do need to see an attorney about filing that notice of intent. If you file a notice of intent on your own because you say, hey, I know who I am, I'm the owner, I know what my farm is, I've got the description, and that may well work out fine. But if there is a problem with that notice of intent, you may be creating a problem with your mineral ownership chain of title from there on out, and expose yourself, if you inadequately describe them, to challenges by others or challenges by surface owners who may own the surface over the mineral interest tracts that you have an ownership interest in. At this point, while I still have a little bit of a voice going here, and I'm still awake because my cold medicine is still working, I'll entertain any questions you have with respect to this. Jason?
If you own the surface rights as well as the mineral rights, is it advisable to reserve those at the present point in time? Must you reserve those at the present point in time?
The notice of intent is designed to place others on notice for mineral interests who do not own the surface. But there's no prohibition for a surface owner who also owns the minerals to file a notice of intent in the land records. And in some cases where there may be questions, it may well be good practice, because after October 1st, that would put any subsequent person claiming ownership of that mineral interest under your surface on notice with respect to any action filed under the act.
And then one follow-up. Every 20 years then, must you update that
Yes.
reservation?
Because the period of time of definition of use is 20 years.
And that reservation suffices as activity per se?
If there was an actual reservation made, that would suffice as use. If there's been no other use, then filing a notice is appropriate. Yes, in the back.
Our mineral right records, are they kept at the courthouse, or where are they filed?
They are kept in the courthouse. If the mineral interest is severed by deed, then that would be in the land records, and any subsequent conveyances of that mineral interest would be among the land records. There are cases where the minerals were severed essentially by will, where great-granddad said, all of the surface of my farm goes to my son, and all of my mineral interest goes to my daughter. And if that estate occurred long ago, there was no separate requirement for a deed to be filed in the courthouse as a result of that estate. So you end up searching the estate records in addition to the land records.
So that's how you trace it back through estate records?
You may have to trace it back through estate records. That's correct. And that's not unique to mineral interests. We sometimes see that with parcels of surface real estate as well. Yes.
A question having to do with developers. Up in the northeast area of Grantsville, there's a development called the Highlands, which is 100 acres parceled up into pieces or lots, I think like 1,000 acres, that was sold to individual people. Now, all this at one time, as the development was formed, was owned by a guy named Ken Wade Jr., who turned out to be an infinite crook, fled to Florida, and our Homeowners Association got a judgment against him in Garrett County Court, $448,000, which he never paid. And we can't get it short of sending Vito and Luigi to visit him or something like that. It may be that he owned the mineral rights. If he tries to sell them to XYZ Natural Gas Company, are we able to blockade that?
You're not
Because he still owes us a big wheelbarrow full of money.
What you're really asking me is a creditor collection question.
Kind of, yeah.
If you can ascertain that Mr. Wade owns the mineral rights, then he has an asset on which you may be able to collect your lien.
Okay.
So the first thing you would need to ascertain is to whether Mr. Wade owns that asset or not, and if it's otherwise encumbered and so forth. So you're asking kind of a dual question. How do you find out if he owns it, and then how do you collect against it?
Got it.
So you can conduct a mineral search on somebody else's minerals if you'd like, and you have an interest in doing so. Yes, in the back.
If you find through your title search that where the mineral rights were separated by a previous owner of the property who maintained the mineral rights when they sold the service, and then the mineral rights are never mentioned specifically again, even within the estate papers and transfers of his estate as he passed. At what point how do you determine who would actually own them? Do they have to be mentioned, I guess? Does it have to be spelled out in a will or a transfer of estate after someone passes in order for him to maintain those rights?
That's a good question. If the mineral interest was owned by John Smith, and at John Smith's death, his will said all of my assets to my son Bob. Well, theoretically, all those assets passed to son Bob, But if it wasn't inventoried in the estate, it wasn't passed forward in that fashion, even prior to the time where a deed would have been required to convey that interest. So we very often see mineral interests that are sort of stuck in old estates. And I've spent time reopening very old estates for that purpose. You reopen the old estate, you get great-great-granddaughter to be the personal representative for that purpose. You do a historical appraisal of that interest, take it out of that estate, and put it forward through all the heirs. Now, if that gets to be a lot of people or a lot of people that are unknown, you can see where that's a challenge to clear title in that fashion that the Dormant Minerals Interests Act could resolve. So that's the part of the analysis, what I mentioned, that once you do a search, you need to sit down and go through an analysis as to which legal method available to you is the best to use in that circumstance. Yes?
If there's no mention in my deed of mineral rights, and I do a mineral search and it shows nothing, do I own the mineral rights?
Yes, if there's no interest, if there's no mention of a reservation of mineral rights, or if there's no affirmative conveyance of the mineral rights in your deed, but there's no prior reservation way back in the chain of title, and you search that thoroughly, then you own the minerals, yes.
Should you file one of these anyway, just in case, or just good to go?
Again, that's a question of if you own the surface and you own the mineral rights and you don't feel that there's any possibility of a contrary claim, then you probably get away with not filing a notice. But I think there are going to be those who choose to file a notice just under an abundance of caution. Yes?
Will you paraphrase the question? Because we can't hear the question. We can hear your answer.
Okay.
Paraphrase the question, please.
Thanks. All right, we'll do that. Thank you.
My question is about the leases that people are signing. Are they saying that they're using blanket mineral rights, or are they specifically mentioning the gas rights on Marcellus Shale?
So the question is, are the leases?
Michael, you're going to step away from the mic or the speaker.
I think your question is, are the gas companies looking for leases that include only gas rights or blanket mineral rights?